Jurisdiction of regional trial courts in civil cases. The regional trial court has exclusive original jurisdiction in all civil actions in which the subject matter of the litigation is incapable of pecuniary estimation. How to determine if an action is incapable of pecuniary estimation? In a line of cases, the Supreme Court held that in determining whether an action is one, the subject matter of which is not capable of pecuniary estimation, the court has adopted the criterion of first ascertaining the nature of the principal action or remedy sought. If it is primarily for the recovery of a sum of money, that claim is considered capable of pecuniary estimation. And whether jurisdiction is in the municipal trial courts or in the regional trial courts would depend on the amount of the claim. However, where the basic issue is something other than the right to recover a sum of money, or where the money claim is purely incidental to or a consequence of the principal relief sought, the Supreme Court has considered such actions as cases where the subject of the litigation may not be estimated in terms of money and are cognizable exclusively by the regional trial courts. Let's discuss the case of Spouses Pajares versus Remarkable Laundry and Dry Cleaning, GR number 212690, Feb 20, 2017. So the facts of this case are as follows. Respondent's counsels designated the complaint as one for breach of contract and damages. So the issue in this case is, can breach of contract be a cause of action which is incapable of pecuniary estimation? Respondent's counsels designated again the complaint as one for breach of contract and damages, which is, according to the Supreme Court, a misnomer and inaccurate. The erroneous notion was reiterated in Respondent's memorandum, wherein it was stated that the main action of the civil case is one for a breach of contract. There is no such thing as an action for breach of contract, according to the Supreme Court. Rather, breach of contract is a cause of action, but not the action or relief itself. So if you remember that once there is a right or substantive right, we've discussed this in the jurisdiction over the subject matter. So once there is a substantive right and there is a violation, it can be a cause of action for an action. And as you remember, the example is if there is the right is due process, the denial of due process can be a cause of action for the action of annulment of judgment of the decision. So the cause of action is different from the action itself. The Supreme Court held that breach of contract may be the cause of action in a complaint for specific performance or rescission of contract, both of which are incapable of pecuniary estimation and therefore cognizable by the RTC. However, breach of contract may also be the cause of action in a complaint for damages. The Supreme Court did not sustain respondent's contention that its complaint is incapable of pecuniary estimation, since it primarily seeks to enforce the penal clause contained in the Remarkable Dealer Outlet contract. And to the mind of the Supreme Court, the responsibility of the petitioner sought to be enforced under the penal clause involves the payment of liquidated damages, which is the amount the parties stipulated to pay in case of breach of contract. The Supreme Court held that, again, what respondent primarily seeks in its complaint is to recover liquidated damages premised on the alleged breach of contract committed by the petitioners when they unilaterally ceased business operations. The Supreme Court cited Article 1170 of the Civil Code, which provides that those who, in the performance of their obligations, are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof are liable for damages. The Supreme Court cited the case of Bachman Incorporated versus Intermediate Appellate Court, where it held that the party who unilaterally terminated the exclusive distributorship contract without any legal justification can be held liable for damages by reason of breach committed pursuant to Article 1170. Okay, so again, the complaint is one for damages. In sum, after juxtaposing Article 4 of the remarkable dealer outlet contract vis-a-vis the prayer sought in respondent's complaint, the court was convinced that the complaint is one for damages. True, breach of contract may give rise to a complaint for specific performance or rescission of contract, as I've mentioned earlier, in which case the subject matter is incapable of pecuniary estimation and therefore jurisdiction is lodged with the RTC. However, breach of contract may also be the cause of action in a complaint for damages. Thus, it is not correct to immediately conclude, as the Court of Appeals erroneously did, that since the cause of action is breach of contract, the case would only either be specific performance or rescission of contract, because it may happen, as in this case, that the complaint is one for damages. Okay? So in sum, if it is breach of contract, it is not automatic that it is specific performance or rescission of contract, because it can be for damages, which is capable of pecuniary estimation. Next, the regional trial court has exclusive original jurisdiction over real actions where the assessed value of the property exceeds 20,000 pesos outside Metro Manila or exceeds 50,000 pesos within Metro Manila, except ejectment cases. So what are real actions? Real action is an action involving title to or possession of real property or any interest therein. Let's discuss foreclosure of mortgage. Roldan versus Spouses Barrios, GR number 214803, April 23, 2018. So the facts of this case are as follows. The regional trial court dismissed the foreclosure cases, finding that the assessed value of the mortgage property is only 13,380 pesos. Hence, according to the RTC, it is the first level court which has jurisdiction over the case and not the RTC. Petitioner cites Russell versus Vestile to show that the action for foreclosure of mortgage is an action incapable of pecuniary estimation and therefore within the jurisdiction of the RTC. So obviously, the issue in this case is whether the RTC committed grave abuse of discretion in dismissing the foreclosure cases filed with it on the ground of lack of jurisdiction. The Supreme Court held that the allegations and relief sought in petitioner's action for foreclosure of mortgage showed that the loan obtained by respondent's Spouses Barrios from petitioner fell due and they failed to pay such loan which was secured by a mortgage on the property of the respondent's spouses. They prayed that in case of default of payment of such mortgage indebtedness to the court, the property be ordered sold to answer for the obligation under the mortgage contract and the accumulated interest. The Supreme Court held that it is worthy to mention that the essence of a contract of mortgage indebtedness is that a property has been identified or set apart from the mass of the property of the debtor mortgager as security for the payment of money or the fulfillment of an obligation to answer the amount of indebtedness in case of default in payment. Foreclosure is but a necessary consequence of non-payment of the mortgage indebtedness. In a real estate mortgage, when the principal obligation is not paid when due, the mortgagee has a right to foreclose the mortgage and to have the property seized and sold with a view of applying the proceeds to the payment of the obligation. Therefore, the foreclosure suit is a real action so far as it is against property and seeks the judicial recognition of a property debt and an order for the sale of the rest. As foreclosure mortgage is a real action, the court held that it is the assessed value of the property which determines the court's jurisdiction. Considering that the assessed value of the mortgage property is only 13,380 pesos, the regional trial court correctly found that the action falls within the jurisdiction of the first level court under BP 129 as amended. The Supreme Court held that in the Russell case, it has already held that in determining whether an action is one, the subject matter of which is not capable of pecuniary estimation, the court has adopted the criterion of first, ascertaining the nature of the principal action or remedy sought. So again, if it is primarily for the recovery of a sum of money, the claim is considered capable of pecuniary estimation, and whether jurisdiction is in the municipal trial courts or in the regional trial courts would depend on the amount of the claim. However, where the basic issue is something other than the right to recover a sum of money, where the money claim is purely incidental to or a consequence of the principal relief sought, then such actions as are cases where the subject of the litigation may not be estimated in terms of money, or in other words, incapable of pecuniary estimation, and are cognizable exclusively by the regional trial courts. Also, the Supreme Court gave examples of actions incapable of pecuniary estimation, such as specific performance, support, foreclosure of mortgage or annulment of judgment, actions questioning the validity of a mortgage, annulling a deed of sale or conveyance, and to recover the price paid, and for rescission, which is counterpart of specific performance. Okay, if you come to think of it, real actions are actions incapable of pecuniary estimations, right? But the law itself specifically mandates that they are cognizable by the MTCs or the RTCs depending on the assessed value of the property. If the assessed value does not exceed 20,000 pesos outside Metro Manila or does not exceed 50,000 pesos within Metro Manila, it is within the jurisdiction of what court? The MTCs. Whereas if the assessed value exceeds 20,000 pesos outside Metro Manila or the assessed value exceeds 50,000 pesos within Metro Manila, it is within the jurisdiction of the RTCs. Okay? The court held that clearly, while civil actions which involve title to or possession of real property or any interest therein are also incapable of pecuniary estimation, as it is not for recovery of money, the court's jurisdiction will be determined by the assessed value of the property involved. Okay, so according to the court, again, while civil actions which involve title to or possession of real property or any interest therein are also incapable of pecuniary estimation, as it is not for recovery of money, the court's jurisdiction will be determined by the assessed value of the property involved. Let us discuss joinder of causes of action. Genesis of Investment Incorporated versus heirs of Ebarasabal, GR number 181622, November 20, 2013. The facts of this case are as follows. The complaint was for declaration of nullity of documents, recovery of shares, partition, damages, and attorney's fees. In filing their complaint with the RTC, respondents sought to recover ownership and possession of their shares in the disputed parcel of land by questioning the due execution and validity of the deed of extrajudicial settlement with sale, as well as the memorandum of agreement entered into by and between some of their co-heirs and the petitioners. Aside from praying that the RTC render judgment declaring as null and void the said deed of extrajudicial settlement with sale and memorandum of agreement, respondents likewise sought the following. Number 1, the nullification of the tax declarations subsequently issued in the name of the petitioner, Cebu Jaya Realty Incorporated. Number 2, partition of the property in litigation. Number 3, reconveyance of their respective shares. And number 3, or not lastly, payment of moral and exemplary damages as well as attorney's fees plus appearance fees. Okay, now the issue is which court has jurisdiction. Do you think it is an action incapable of pecuniary estimation under the RTC's jurisdiction? Or do we have to determine the assessed value first so that we can determine whether or not it's the MTC or the RTC. What do you think? The court held that it is true that one of the causes of action of respondents pertains to the title, possession, and interest of each of the contending parties over the contested property, or in other words, a real action, the assessed value of which falls within the jurisdiction of the MTC. However, a complete reading of the complaint would readily show that, based on the nature of the suit, the allegations therein, and the reliefs prayed for, the action is within the jurisdiction of the RTC. Why? Clearly, because this is a case of joinder of causes of action, which comprehends more than the issue of partition of or recovery of shares or interest over the real property in question, but includes an action for declaration of nullity of contracts and documents which is incapable of pecuniary estimation. Correct. So, using the principal relief test, okay, the Supreme Court held that contrary to petitioner's contention, the principal relief sought is the nullification of the subject extrajudicial settlement with sale entered into by and between some of their co-heirs and respondents insofar as their individual shares in the subject property are concerned. Thus, the recovery of their undivided shares or interest over the disputed lot, which were included in the sale, simply becomes a necessary consequence if the deed is nullified. Hence, since the principal action sought in respondent's complaint is something other than the recovery of a sum of money, the action is incapable of pecuniary estimation and thus cognizable by the RTC. Okay, well entrenched is the rule that jurisdiction over the subject matter of a case is conferred by law and is determined by the allegations in the complaint and the character of the relief sought, irrespective of whether the party is entitled to all or some of the claims asserted. Another case, redemption of a land under free patent. Heirs of Bautista versus Lindo, GR number 208232, March 10, 2014. In this case, the course of action embodied in the complaint by the present petitioner's predecessor, Alfredo Bautista, is to enforce his right to repurchase the lots he formerly owned pursuant to the right of a free patent holder under Section 119 of C 141 or the Public Land Act. So, okay, take note, the action is to enforce the right to repurchase the lots under the right of a free patent holder. The issue in this case is whether the action filed by petitioners is one involving title to or possession of real property or any interest therein, or a real action, or one incapable of pecuniary estimation. The Supreme Court held that the complaint to redeem a land subject of a free patent is a civil action incapable of pecuniary estimation. And in explaining so, the court gave examples of actions incapable of pecuniary estimation, such as actions for specific performance, actions for support which will require the determination of the civil status, the right to support of the plaintiff, those for the annulment of decisions of lower courts, those for the rescission or reformation of contracts, and those for the interpretation of a contractual stipulation. The Supreme Court held that the instant cause of action to redeem the land is one for specific performance. So the facts are clear that Bautista sold to respondents his last lots which were covered by a free patent, while the deeds of sale do not explicitly contain the stipulation that the sale is subject to repurchase by the applicant within a period of 5 years from the date of conveyance pursuant to Section 119 of CE 149, still, such legal provision is deemed integrated and made part of the deed of sale as prescribed by law. So it is basic that the law is deemed written into every contract. So although a contract is the law between the parties, the provisions of positive law which regulate contracts are deemed written therein and shall limit and govern the relations between the parties. Thus, it is a binding prestation in favor of Bautista which he may seek to enforce. That is precisely what he did, okay? He filed a complaint to enforce his right granted by law to recover the lot subject of free patent. Ergo, it is clear that his action is for specific performance, or if not strictly such action, then it is akin or analogous to one of specific performance, okay? Such being the case, his action for specific performance is incapable of pecuniary estimation and cognizable by the RTC, okay? How about annulment of real estate mortgage? Let's discuss the case of First Sarmiento Property Holdings, Incorporated versus Philippine Bank of Commerce, GR number 202836, June 19, 2018. The facts of this case are as follows. Petitioner contends that its complaint for annulment of real estate mortgage has a subject incapable of pecuniary estimation because it was not intended to recover ownership or possession of the mortgaged property sold to respondent during the auction sale. So it insists that it had ownership and possession of the mortgaged properties when it filed its complaint. Hence, it never expressly or impliedly sought recovery of their ownership or possession. The issue in this case is whether or not the RTC obtained jurisdiction over First Sarmiento Corporation Incorporated's complaint for annulment of real estate mortgage. So the court stressed that where the money claim is only a consequence of the remedy sought, the action is said to be one incapable of pecuniary estimation. Where or if the primary cause of action is based on a claim of ownership or a claim of legal right to control, possess, dispose, or enjoy such property, the action is a real action involving title to real property. Now, the court held that a careful reading of petitioner's complaint convinced it that petitioner never prayed for the reconveyance of the properties foreclosed during the auction sale, or that it ever asserted its ownership or possession over them. Rather, it assailed the validity of the loan contract with real estate mortgage that it entered into with respondent because it supposedly never received the proceeds. This is evident in the complaint. So the court said that an action for cancellation of mortgage in one case has been said to be a subject that is incapable of pecuniary estimation. How about the ultimate motive of the complaint? Now, in the same case of First Sarmiento, the court held that finally there is a need to reassess the place of the case of home guarantee versus R2 builders in our jurisprudence, considering that the principal remedy sought by R2 builders was the resolution of the deed of assignment and conveyance. The action was incapable of pecuniary estimation, and home guarantee erred in treating it as a real action simply because the principal action was accompanied by a prayer for reconveyance of real property. So, okay, take note of that. So, if there is a prayer for conveyance of real property in the complaint, it does not automatically mean that the action is a real action. There must still be an examination of the allegations in the complaint. It is clear that the subject matter jurisdiction cannot be dependent on the supposed ultimate motive or true objective of the complaint, because this will require the judge to speculate on the defenses of the plaintiff beyond the material allegations contained in the complaint. Likewise, in attempting to pinpoint the true objective of the complaint at the initial stages of the trial, the judge might end up dictating the result outside of the evidence still to be presented during the trial, opening up the judge to charges of partiality and even impropriety. Furthermore, the judge is not aware of the evidence to be presented by either party when the complaint is filed. Thus, there is no reliable basis that can be used to infer the true objective of the complaint. It is imperative, then, that the competing claims as basis of subject matter jurisdiction be textually based, finding its basis in the body of the complaint and the relief sought without reference to extraneous facts not alleged, or evidence still to be presented. So in light of the foregoing, the Supreme Court reaffirmed that the nature of an action is determined by the principal relief, the principal relief test sought in the complaint, irrespective of the other causes of actions that may also crop up as a consequence of the principal relief prayed for. The contrary rule espoused in the home guarantee case is or was set aside by the Supreme Court. Okay, next, the regional trial court has exclusive original jurisdiction over actions in admiralty and maritime jurisdiction where the demand or claim exceeds 300,000 pesos outside Metro Manila or exceeds 400,000 pesos in Metro Manila. The Supreme Court has issued AM number 05-4-05-SC, which provide that the court resolved upon the recommendation of the Office of the Court Administrator to designate the special courts for commercial cases to try and decide cases involving admiralty and maritime laws. The regional trial court has exclusive original jurisdiction over matters of probate, testate, and intestate where the gross value of the estate exceeds 300,000 pesos outside Metro Manila or exceeds 400,000 pesos in Metro Manila. Next, the regional trial court has exclusive original jurisdiction over actions involving the contract of marriage and marital relations. The Family Courts Act of 1997, or RA number 8369, Section 5D thereof provides that the Family Court has exclusive original jurisdiction over complaints for annulment of marriage, declaration of nullity of marriage, and those relating to marital status and property relations of husband and wife, or those living together under different status and agreements, and petitions for dissolution of conjugal partnership of gains. So based on this law, the family courts have jurisdiction over cases or contract of marriage and marital relations. Let us discuss the case of Tilar versus Tilar, GR number 214529, July 12, 2017. In this case, the court ruled that a petition for declaration of nullity of marriage, which petitioner filed before the RTC of Baybay City, falls within its exclusive jurisdiction. Thus, the RTC erred in dismissing the petition for lack of jurisdiction. So if you remember the ruling or our discussion in the court regarding special jurisdiction and general jurisdiction, so in this case, if a case is filed before the RTC, which includes the contract of marriage or marital relations, the RTC should not dismiss the case, and it should refer the case to a family court, because a family court is an RTC designated as a family court. Since it is still an RTC, then the general jurisdiction of the court remains, and the case is within its jurisdiction. Okay, next, the regional trial court has exclusive original jurisdiction over cases not within the exclusive jurisdiction of any court, tribunal, person, or body exercising judicial or quasi-judicial functions. So this pertains to the general jurisdiction of the regional trial court as provided in BP 129 as amended. Next, the regional trial court has exclusive original jurisdiction over civil actions and proceedings falling within the exclusive original jurisdiction of a juvenile and domestic relations court and of the Court of Agrarian Relations as now provided by law. Take note that there are no more juvenile and domestic relations court today. Under BP 129, the functions of the Juvenile and Domestic Relations Court have been transferred to the regional trial courts. How about the Court of Agrarian Relations? So in 1980, upon the passage of BP 129, otherwise known as the Judiciary Reorganization Act, the courts of agrarian relations were integrated into the regional trial courts, and the jurisdiction of the former was vested in the latter courts. However, with the enactment of Executive Order number 229, which took effect on August 29, 1987, the regional trial courts were divested of their general jurisdiction to try agrarian reform matters. The said jurisdiction is now vested in the Department of Agrarian Reform. So let us analyze this. The Department of Agrarian Reform has jurisdiction over agrarian reform matters, whereas the RTC that are designated as special agrarian courts has jurisdiction over the determination of just compensation and the prosecution of criminal offenses under the said act. Okay, RA number 6657, or the Comprehensive Agrarian Reform Law, which took effect on June 15, 1988, contains provisions which support the intention of the legislature to vest in the Department of Agrarian Reform exclusive jurisdiction over all agrarian reform matters. Section 50 of said law substantially reiterates Section 17 of EO number 229, vesting in the Department of Agrarian Reform exclusive and original jurisdiction over all matters involving the implementation of agrarian reform. So to be specific, Section 50 of the law provides for the quasi-judicial powers of the DAR, or the Department of Agrarian Reform, or the DAR. So the DAR is hereby vested with primary jurisdiction to determine and adjudicate agrarian reform matters and shall have exclusive original jurisdiction over all matters involving the implementation of agrarian reform, except those falling under the exclusive jurisdiction of the Department of Agriculture and the Department of Environment and Natural Resources. So in addition, Section 56 and 57 of the same law provide for the designation by the Supreme Court of at least one branch of the regional trial court within each province to act as a special agrarian court. Okay, the said special court shall have original and exclusive jurisdiction only over petitions for the determination of just compensation to landowners and the prosecution of criminal offenses under the said act. Said provisions delimit the jurisdiction of the regional trial courts in agrarian cases only to these two instances. Okay, so Section 56 of the law provides for the special agrarian court. The Supreme Court shall designate at least one branch of the regional trial court within each province to act as a special agrarian court. Okay, the Supreme Court may designate more branches to constitute such additional special agrarian courts as may be necessary to cope with the number of agrarian cases in each province. In the designation, the Supreme Court shall give preference to the regional trial courts which have been assigned to handle agrarian cases or whose presiding judges were former judges of the defunct Court of Agrarian Relations. Section 57 provides for the special jurisdiction. It provides that the special agrarian court shall have original and exclusive jurisdiction over all petitions for the determination, again, of just compensation to landowners and the prosecution of all criminal offenses under the Act. The rules of court shall apply to all proceedings before the special agrarian courts unless modified by the Act. Okay? So again, the RTCs have not been completely divested of jurisdiction over agrarian reform matters. The law confers jurisdiction on special agrarian courts to what cases again? Number 1, all petitions for the determination of just compensation to landowners, and number 2, the prosecution of all criminal offenses under the Act. Where to appeal the decision of the special agrarian courts? So under the same law, Section 60, appeals, an appeal may be taken from the decision of the special agrarian courts by filing a petition for review with the Court of Appeals. Okay? So an appeal from the decision of the Court of Appeals or from any order, ruling, or decision of the Department of Agrarian Reform, as the case may be, shall be by a petition for review with the Supreme Court within a non-extendable period of 15 days from receipt of a copy of said decision. All right. The special jurisdiction of the SAC-RTC, or the Special Agrarian Courts, is conferred and regulated by the Comprehensive Agrarian Reform Law, and appeals therefrom are governed by Section 60, as I have mentioned. That law expressly states that appeals from SACs must be taken to the Court of Appeals without making a distinction between appeals raising questions of fact and those dealing purely with questions of law. Okay, next, the Regional Trial Court has exclusive original jurisdiction in all other cases in which the demand, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses and costs, or the value of the property in controversy exceeds 300,000 pesos in outside Metro Manila or exceeds 400,000 pesos in Metro Manila. We will discuss this provision in our discussion on totality rule. The Regional Trial Court has exclusive original jurisdiction over cases falling under Section 5 of PD number 902A, transferred from the Securities and Exchange Commission. Okay, so the Commission's jurisdiction over all cases enumerated under Section 5 of PD 902A was transferred to the Courts of General Jurisdiction, or the appropriate regional trial courts. So what are these cases? These cases include, first, devices or schemes employed by or any acts of the Board of Directors, business associates, its officers or partners amounting to fraud and misrepresentation, which may be detrimental to the interest of the public and or of the stockholder, partners, members of associations or organizations registered with the Securities and Exchange Commission. Next, controversies arising out of intra-corporate or partnership relations between and among stockholders, members, or associates, between any or all of them and the corporation, partnership, or association of which they are stockholders, members, or associates, respectively, and between such corporations, partnership, or association and the state insofar as it concerns their individual franchise or right to exist as such entity. And finally, controversies in the election or appointments of directors, trustees, officers, or managers of such corporations, partnerships, or associations. Okay, the Regional Trial Court shall exercise original jurisdiction in the issuance of writs of certiorari, prohibition, mandamus, quo warranto, habeas corpus, and injunction, which may be enforced in any part of their respective regions. The Regional Trial Court exercises original jurisdiction in actions affecting ambassadors and other public ministers and consuls. Now, let us discuss the jurisdiction of regional trial courts in criminal cases. The Regional Trial Court shall exercise exclusive original jurisdiction first in all criminal cases not within the exclusive jurisdiction of any court, tribunal, or body, except those now falling under the exclusive and concurrent jurisdiction of the Sandigan Bayan, which shall be exclusively taken cognizance of by the latter. The Regional Trial Court has exclusive original jurisdiction over offenses the imposable penalty for which exceeds 6 years of imprisonment. The Regional Trial Court has exclusive original jurisdiction in cases where the only penalty is fine, then the amount thereof shall determine jurisdiction. If the amount exceeds 4,000 pesos, RTCs have jurisdiction. The Regional Trial Court has exclusive original jurisdiction over criminal cases under specific laws, such as libel cases, violation of the Comprehensive Dangerous Drugs Act, violation of intellectual property rights or intellectual property code. The Regional Trial Court has exclusive original jurisdiction over all cases on money laundering except those falling under the jurisdiction of the Sandigan Bayan. The Regional Trial Court has exclusive original jurisdiction over election offenses. How about appellate jurisdiction? Regional trial courts shall exercise appellate jurisdiction over all cases decided by MTCs in their respective territorial jurisdictions. The decision of the regional trial courts in such cases shall be appealable by petition for review to the Court of Appeals. Special jurisdiction of the regional trial court. So, the Supreme Court may designate certain branches of the regional trial courts to handle exclusively criminal cases, juvenile and domestic relations cases, agrarian cases, urban land reform cases, which do not fall under the jurisdiction of quasi-judicial agencies and bodies, and or such other special cases as the Supreme Court may determine in the interest of a speedy and efficient administration of justice. This is provided under BP 129 or the Judiciary Reorganization Act of 1980.